Rise. All Rise radio show brings exciting and varied legal topics to listeners. The show highlights key legal aspects, legal tips, and information from experts and specialists, featuring lawyers, consultants, economics, and many more. The show touches nearly every aspect of daily life and brings both exciting and entertaining stories, along with helpful tips, such as how to hire the perfect lawyer and how not to waste money. Join me, your host, Ibaa Al Masri.
Assalamu alaikum warahmatullahi wabarakatuh. Good evening, everyone, and welcome to a new episode of All Rise. Your host is Ibaa Al Masri. I'm behind the mic, and our sound engineer Abdullah Qahtani. Thank you so much. So, in All Rise, if this is your first episode to be with us, we are here to talk about some legal aspects that would be very beneficial and important to lots of people here in Saudi Arabia. We highlight some key legal aspects of law regarding sometimes contracts, some employment contracts, and many more. So for now, we are going to talk about an important subject. So our title or topic for today is going to be the employment contracts. Yes, it's a big subject. It's huge, actually. If you want to talk about it, debriefing some important points, it's going to take like a lot. So for that, instead of debriefing, I'm here to brief some important points according to what you need to know about the employment contract, and we might extend it to the next episode to talk about some important things to spot before signing a contract. The employment contract is something that might occur in our life at one point. Sometimes we look forward to sign an employment contract. Sometimes we maybe already did that. And an expat would come to Saudi Arabia for work, would have had so many contracts to sign, and some of you actually would be looking forward to be engaged with an agreement or an employment contract. Sometimes we get into the courtesy with the employer not to actually check for all the clauses of that contract. So we're just there looking for that job, and we just want to get into this job. And we already talked about some important issues, such like the salary, maybe the commission, and some essential parts where the job is and the duration. But sometimes there are these clauses that we really need to look at in order not to have any trouble in the future, neither us or the employer himself. And we always look at it as in a perspective of not having any dispute in the future. So, dear listeners, we are going to talk about some important points in your maybe next contract of employment to spot, and that would save you lots of time and effort and maybe troubles. Stay tuned. All right, welcome back. So, what is the employment contract? It is a contract concluded between an employer and a worker in order to complete or perform a job for an agreed wage. So, some important information that I might share with you that would benefit a lot to know how to deal with that contract, and knowing your right would be as follows. So, the work contract shall be duplicates. One copy to be retained by each of the two parties. So sometimes we might face this employer who would say, okay, so sign this document and I'll keep it with me. It is our right as an employee to keep a copy of that contract with me. So it should be actually a copy of two. One original with me and the other original can be kept with the employer. This problem is solved now because contracts are actually been digitalized. So once you sign this contract, even if it was a hard copy, after it's been uploaded to the system, you are going to receive a soft copy of that, and it will be via a link. I highly recommend you click that link and check if that digital contract is the same as the hard copy contract that you already signed. Check all the clauses, everything, and you have the right to ask questions. Then you can just accept the terms and conditions, you can just accept the contract, and this is how it goes. So the second thing is that the work contract for non-Saudis shall be written and of a specified period. If the contract does not specify a duration, the duration of work permit shall be deemed as the duration of a contract. So as a non-Saudis or as an expat, our contracts are kind of limited in time. So they're not indefinite, they're definite. So for that, only the Saudi person is having the indefinite contract, which is like an open-ended. However, if a different kind of contract was given to a non-Saudi, it doesn't mean that the work is illegal. And it doesn't mean that the work is being done in an illegal way. You still deserve your wage, your compensation, and everything. So it's considered that there's still a contract is active and legal and binding. But what about the end of that contract? The end of that contract is deemed according to the work permit. So a non-Saudi would be having a work permit, and that's sometimes different than the ID or Iqama. It is there, anyone can check it on Abshir. So the work permit would be the end of the contract if it was indefinite. Another thing is a contract shall be deemed to exist even if was not written, and either party is entitled to ask for a draft of the contract at any time. If you think that not having a contract won't allow you to claim your benefits, you're wrong. Not having a contract, like a written one, is not a problem. You can still provide evidence of having work with an employer, and the employer can provide an evidence of having work or giving some errands to an employee by all types of evidence providing, such as bank transfer for the salary, requests via email, via WhatsApp, or via letters. In this case, a contract is been put into action even if it was not written, even if it was like an oral engagement. And a default contract will be taken from the labor law. However, we never recommend starting a work without having a contract. At that time, it's very important, it's actually essential to get into a binding written contract with an employer, because this is the best way to reserve all the rights for the employee and for the employer. We will get back after a short break. And welcome back. So, what is the typical element that should be there in the work contract? Actually, there are quite a few. The work contract shall primarily include as follows: the name of the employer and his venue, and at these times we can mention the venue as the national address. Yes, it is very important. The name of the worker and his nationality, paperwork providing identification, place of residence, wage agreed upon, privileges and allowances, type of location of work, date of employment, duration of the contract. So, for the venue or the national address, what we see now, according to the labor court or labor office or even the friendly settlement committees, the national address is a key of the employer. So make sure that the employer has got a national address and even a CR, which is the commercial registration of the employer. It is a key, and make sure that the CR is actually the same as the CR of your sponsor. It will save you a lot of time in case you're filing a case against the employer in the future. And it's binding by law that you need to work with the same employer that you have the sponsorship upon. Now the sponsorship has been changed. It's more like a service, kind of changing the service. It's not a person who is a sponsor. It's an establishment more like, or a company. And your contract is what determines your sponsorship. So it's easier because it gives you the freedom to change in between work after 1 year of being at one employer as an expat. Also, the paperwork providing identification, ID or passport are very important. They are key to provide an evidence about your identity. Of course, place of residence, and what is the wage that you are agreeing on. Is it a basic salary? What are the allowances? What are the privileges you're having? What are the commissions? What are the incentives? Every Saudi riyal that you're getting paid should be mentioned there at the work contract. It shouldn't be just mentioned in a way that it's not clear. It should be mentioned clearly. And these are the essential things that be put especially at the beginning, at the preamble. And then we can talk about an important aspect, which is the probation period after a short break. And welcome back. So let's talk about the probation period. The probation period might be a little bit tricky. It might be scary. It might mean that, I won't have any job security for the next 3 months or 6 months. Yeah, 6 months, can you imagine? But sometimes it might not be mandatory. So if there is a probation period, it should be mentioned clearly within the contract in written. And it means that it's been agreed upon from both the employer and the employee. According to the labor law, such probation period shall not exceed 90 days. And actually, and this is something not all of people know, it might be extended to 180 days only upon a written consent from the worker or the employee. So if the probation period is going to be more than 3 months, you should be aware of it as an employee, and you should actually agree on that. Signing the contract would be a written confirmation from you that you actually accept the 6 months probation period. Wow, too long, right? So it might be actually being put, why do we ask for written approval? Because in the contract, it might be only 3 months, and then maybe the employer would ask for another probation period, and that would be another 3 months. It can be actually implemented according to the approval from the worker, and that should be in writing. What about if we want to even extend it for more? Actually, it can happen. It is allowed, but just under limited conditions. So the worker may, with the approval of the contract parties, be subject to another probation period on the condition that, first, this period involved another profession. So let's imagine that the employer is changing the profession of that employee. He's working in sales, but we're changing the major into operation management. Something way different. So from sales to maybe reception or customer service, that's a way different profession. So in this case, the employer is allowed to put the employee under another probation period. Or maybe even another work. So the employer changed the place of work of that employer, and that consequently led to changing the work of that employee. The employer is allowed to actually implement another probation period. The third one is a period at least 6 months elapsed since the termination of the work relation between the worker and the employer. So if the contract has been terminated and the employee left the employer for 6 months plus and then returned back, this is where the employer is actually allowed to put the employee under another probation period. So you should know what is allowed by the employer and what's not as an employee. And even for the employers, you should know that having more and more probation periods and just adding days by days and months to that might be not legal. So make sure to get your decisions to be aligned with the labor law. We are getting to the last part of our episode after a really quick break. Welcome back. So, before we finish this episode, let's talk about some general rights in the work contract. A worker actually may not be assigned duties which are essentially different from the work agreed upon without his written consent, except in cases of necessity. That is going to be circumstances happening or occurring to the employer with a period that is not exceeding 30 days. So usually, that's why it's very important to check what are the duties and what is the type of work that I'm doing, that it should be written in the contract. The law is not allowing the worker to assign different duties to the employer unless there is kind of some special circumstances. So in case of an extreme necessity, the employer may assign the worker without a consent to perform a work which is essentially different from the work agreed upon for a period not exceeding 30 days a year. So let's imagine that a flood happened or a fire happened, and the employer is not allowed or cannot actually do the same job as been done. So let's say it was a car agency. So the employer won't be able now to go on with the work. This is where the employer is allowed, according to these special circumstances, to ask the workers to do something different because of this necessity not to exceed 30 days. However, the employer shall bear the cost of transportation and accommodation of the work throughout this period. So if these circumstances led into any kind of different accommodation or transportation, the employer should bear the cost. If the contract involves performance of a specific work, it shall terminate with the completion of the work agreed upon. Make sure that if the contract is only regarding that kind of project, let's say you're an engineer or an architect, and the contract is only regarding this kind of work, once the job is done, the contract is terminated automatically. So these are some of the, I won't say important because there are a lot of important things and keys in the employment contract. I could talk about them forever, but I tried my best to brief some important points here. We will go on to talk about some other important points regarding the renewal of the work contract, the termination of the contract, and some cases. Also, we're going to talk about when the employee is set free to leave the work and what is the importance of not just leaving the work without doing some important steps. I'm trying to excite you to the next episode. So since then, enjoy the evening. I'll see you inshallah on Wednesday at 6 p.m. KSA time with a new episode of your legal radio show, All Rise, with me, your host, Ibaa Al Masri, and with the control we have Abdullah Gahtani. Thank you so much for your time. Stay safe. I'll see you soon. Bye.